All right, so picture this. You're running a business, right? Things are going pretty smoothly, and then bam, you hit a snag, a disagreement over some numbers in a contract. Seems like a minor hiccup at first.
Right.
But fast forward a few years and you find yourself caught in a full-blown legal whirlwind. You're battling it out in court, the stakes are high, and everyone's watching because this case has gone viral.
Wow.
Sounds a bit dramatic, huh? Well, that's exactly the story we're diving into today. A viral Supreme Court showdown right here in the Philippines, starring the Philippine Charity Sweepstakes office, PCSO, the lotto folks,
Yeah.
and a company called DFNN Incorporated. Now, at the heart of this legal drama is a technology deal gone wrong, a project for a mobile lotto platform. Think early days of betting on your phone. We've received a ton of questions about this case, so tonight we're breaking it down. We're going to sift through the legal jargon, lay out the facts, the journey through the courts, all the way up to the Supreme Court's final word. No need to be a legal eagle for this. We'll keep it clear and concise, just like your nightly news. Ready to untangle this legal web.
Absolutely. Let's get into it. So this whole saga really kicks off with an agreement, an equipment lease agreement, they call it ELA for short, signed back on April 9, 2003 between PCSO and DFN.
And ELA. And this is basically laying out the terms for DFNNI to build this mobile lotto platform, right? A pretty novel concept at the time.
Yeah, you could say that. I mean, this was 2003, so the whole mobile landscape was totally different. But the idea was there, people would be able to place their lotto bets using those little phones we had back then.
Oh, yeah, the ones with the tiny screens and the buttons.
Exactly. So under this ELA, DFNNI was responsible for the whole shebang, designing a system, developing it, keeping it up to date, the works. And get this, PCSO agreed to exclusively lease everything from them. The hardware, the software, even the technical know-how, all from DFNNI.
Exclusivity. So PCSO is really putting all its eggs in one basket with this deal. And I'm guessing this exclusivity clause, it plays a big role in the legal battle later on.
You bet. And there's another little detail tucked away in the ELA that becomes super important, an arbitration clause, basically saying if any squabbles pop up, they'll be settled through arbitration, not by going to court directly.
Interesting. So a way to keep things out of the public eye and resolve disputes more quickly? In theory.
In theory, yes. But things don't always go according to plan, do they? Because fast forward to March 9, 2005, not even 2 years into this agreement, PCSO pulls the plug. They issue a board resolution, number 80, series of 2005, officially rescinding the ELA.
Wow, a sudden stop. What went wrong? Why did PCSO decide to back out of this mobile lotto deal?
Well, they gave a bunch of reasons. The main one they put forward was that DFNNI, they weren't able to secure the cooperation of the big telecom players at the time. We're talking Globe, Smart, the Giants.
Yeah, those were the big names back then. Makes sense that you'd need their buy-in for a mobile platform to really take off.
Right. I mean, without those guys, you're reaching a very limited audience. And actually, there's some interesting back and forth in the internal communications. PCSO claims DFNNI just didn't deliver, while DFNNI kind of suggests it was PCSO's responsibility to get those telecom giants on board. A bit of a he said, she said situation.
Ah, finger pointing. Always a good sign. But beyond those major telecom players, what other concerns did PCSO raise?
They also brought up the less than enthusiastic response from some of the smaller players, Sun Cellular, Nextel, those guys. And PCSO argued that with the big players out and only lukewarm interest from the smaller ones, the project just wasn't going to be profitable. The projected income, it just wasn't there anymore.
So financial viability, or rather the lack of it, becomes a key factor in PCSO's decision. Any other major concerns that tip the scales?
Oh, there's more. PCSO also got a warning from the Philippine Gaming Management Corporation, PGMC, about some potential security risks. They were worried that connecting DFNNI's mobile platform to the PCSO's main online lottery system could compromise the whole system's security. You can imagine that's a big no-no when you're dealing with lottery operations. Got to keep things airtight.
Absolutely. Any whiff of a security breach would be a disaster for their credibility. So we've got telecom troubles, financial concerns, security anxieties. But PCSO didn't stop there, did they?
Nope, they went even further. They started questioning the whole legality of the EA, suggesting it might clash with existing laws, ethical guidelines, even public policy. They also cast doubt on whether DFNNI actually had the authority to sign this agreement in the first place.
Okay, so now they're bringing in the legal heavyweights.
Yeah, they're throwing everything but the kitchen sink at this point. They also pointed out that there was no public bidding for the project, and to top it all off, there were some minutes from crucial meetings regarding the authorization of the ELA that were, get this, unsigned.
Oh, that's messy. Unsigned documents in a major deal like this? Not a good look.
Not at all. It's like, wait, who actually signed off on this? So yeah, PCSO had racked up a whole laundry list of complaints. They officially informed DFNNI about this rescission in a letter dated April 5, 2005. And as you can imagine, DFNNI was not happy about this sudden termination.
I bet. What do? Do they just accept PCSO's decision and walk away?
Not a chance. They tried to find some middle ground, avoid a full-blown legal battle. They sent letters to PCSO in December 2005 and then again in December 2007 proposing to sit down and hash things out amicably. But PCSO, they weren't interested in these peace talks.
Sounds like PCSO was pretty firm in their decision to terminate. So with those attempts at a friendly resolution failing, what was DFNNI's next move?
Well, remember that arbitration clause we talked about earlier? That became their path forward. They initiated arbitration proceedings, seeking a hefty sum from PCSO for what they considered an unjustified termination.
Okay, so they're taking it to the arbitrators. How much were they asking for?
They were seeking a whopping 1,913,948,850 pesos. To be exact, 1,913,948,850.00. Yeah, almost 2 billion pesos.
That's a huge sum of money. What was their justification for such a massive claim?
The bulk of it, 1.9 billion to be precise, was for what they called liquidated damages. Essentially, they were claiming the revenue they would have earned if the mobile lotto platform had gone ahead as planned.
Ah, so lost potential earnings. That's a common element in contract disputes. But they didn't stop there, did they?
Nope, they piled on additional claims for temperate damages, which are kind of like a catch-all for damages that are hard to quantify precisely. And of course, they wanted PCSO to cover their legal fees and other costs associated with the case.
So DFNNI comes out swinging, claiming billions in damages. What was PCSO's defense strategy in the arbitration?
PCSO stuck to their guns. They basically reiterated all the reasons they had given for the rescission. DFNNI's alleged failures to integrate with PGMC and Pacific Online, their inability to bring those major telecom players on board, and the fact that they hadn't delivered the system within the agreed-upon timeframe. All those points we talked about earlier, they were back on the table.
So a classic, we were justified in terminating defense. It all boils down to whether the arbitrators would agree with PCSO's interpretation of those failures and whether they were significant enough to warrant such a drastic step as termination. What was the outcome of the arbitration? Did the panel side with PCSO or DFNNI?
Well, the arbitration panel, they issued their award on May 21, 2015, and get this, they sided with DFNNI on the main issue. They declared that PCSO's rescission was improper.
Really? So they agreed that PCSO wasn't justified in terminating the agreement.
That's right. However, they didn't give DFNNI the full amount they were demanding. Not even close. They awarded them 27 million pesos in liquidated damages, a far cry from the nearly 2 billion they were seeking. And they ordered PCSO to return the equipment DFNNI had provided for the project.
Wow, that's a massive difference. How did the panel arrive at that specific amount of 27 million?
They based it on a specific clause in the EA, Section 13.2 Atai to be exact. This clause stated that in case PCSO defaulted, the liquidated damages would be calculated based on the market value of the system.
Interesting. So not just a random number plucked out of thin air, but a figure tied to a specific provision in their contract. What about DFNNI's other claims, those temperate damages, the attorney's fees, all that?
The panel shut those down. They said the claim for unexpired term rental payments were way too speculative because, well, the mobile platform never even launched. And the 2% interest claim, they explained that this was specifically linked to unpaid lease rentals, and since no rentals were actually due, that claim was also dismissed.
Okay, so the arbitration panel throws out a curveball, says PCSO messed up by terminating the contract, but then only awards a fraction of what DFNNI wanted. You'd think that would be the end of it, but of course this is just the beginning of the legal saga, right?
Oh yeah, things are just getting warmed up. Both sides decided to take this further into the court system.
Round 2, the court battle begins. So walk me through the next chapter. Who filed what and where?
All right, so on June 25, 2015, PCSO, they file a petition for confirmation of the arbitral award. They went to the Regional Trial Court in Mandaluyong City for this.
Makes sense. They want the court to officially recognize and enforce the arbitrator's decision.
Exactly. But the very next day, DFNNI files their own petition. This one's a petition for correction of the arbitral award, and they filed it with the RTC in Makati City.
Hold on, 2 petitions, 2 different courts for the same award. That seems a bit, well, inefficient. What was DFNNI's angle here? Why did they want the award corrected?
They argued there was a big blunder in the calculation of the damages. They claimed they were actually owed way more than the 27 million the arbitrators awarded. They wanted a total of over 310 million pesos.
Wow, a substantial difference. What was their rationale for this hefty increase?
Well, they claim they were entitled to a 2% monthly penalty on top of the initial $27 million. Plus, they brought back their claims for temperate damages and attorney's fees, which the arbitrators had tossed out. Their argument was that the ELA, the original agreement, it actually supported this calculation. They just interpreted it differently than the panel did.
So a classic contract interpretation battle, each side pointing to the same document but coming up with wildly different numbers. All right, we've got two RTCs, one in Mandaleon, one in Makati, grappling with this case. What happened next? How did they rule on these petitions?
Okay, so the RTC and Makati, they released their decision first on February 17, 2016, and guess what? They sided with DFNNI. They agreed that the damages needed correcting and bumped them up to that $310 million figure, including the 2% monthly penalty. They also added a 6% annual interest on this new total, starting from the date the decision became final.
A win for DFNNI in Makati. What about the RTC in Mandaleon? Did they just rubber stamp the arbitrator's original decision?
Well, before ruling on the confirmation, they first had to deal with DFNNI's request to consolidate the two cases, bring them together under one court.
Yeah, it makes sense to avoid conflicting rulings from two different courts. What did the Mandaleon RTC decide?
They actually denied the consolidation request. They said, look, under the special ADR rules, we have the discretion to decide on these matters.
Interesting. So even though the cases are clearly related, the Mandaleon court wasn't obliged to merge them.
Right. Then they went ahead and issued their decision on January 5, 2017, and they went the opposite way of the Makati RTC. They confirmed the original arbitral award of 27 million pesos. They didn't buy into the evident miscalculation argument and agreed with the arbitrator's interpretation of the 2% interest clause.
So we've got a split decision. Makati increases the award. Mandaleon sticks with the original. The legal plot thickens. Where do things go from here?
Upward. To the Court of Appeals. PCSO, they weren't too happy with the Makati RTC's decision, so they appealed it. That appeal was docketed as C-GR SP number 145983.
And DFNNI, they likely appealed the Mandaleon decision, right?
You bet. They weren't thrilled about the consolidation denial. That appeal became CA-GR SP number 145462. So the Court of Appeals had two separate appeals to deal with, both stemming from the same arbitration award.
Talk about a legal maze. Okay, what did the Court of Appeals do? Did they manage to untangle this mess?
Well, they issued their decision on the PCSO appeal first on November 17, 2016, and they sided with DFNNI. They upheld the Makati RTC's decision confirming the increased $310 million award. They weren't convinced by PCSO's arguments about forum shopping, lack of jurisdiction, or that there was no miscalculation in the original award.
Wow, another win for DFNNI. What about their own appeal regarding the consolidation?
They got good news there, too. The Court of Appeals granted their petition on February 20th, 2017. They said, yep, those cases should have been consolidated. They even pointed out that PCSO's confirmation petition in Mandaluyong was filed a bit prematurely. It was just 1 day shy of the 30-day waiting period suggested by the special ADR rules.
Ah, so a little procedural hiccup on PCSO's part.
Yeah, it could be seen that way. And the Court of Appeals emphasized the general principle that related cases should be combined to prevent those conflicting judgments we were talking about earlier.
Makes sense. Efficiency in the courts, that's always a good thing. But now we've got the Court of Appeals siding with DSNNI on both appeals, upholding the higher award and ordering the consolidation. This seems like a decisive victory for DFNNI. Was it the end of the line?
Not quite. Remember, in the Philippines, we have a Supreme Court. And PCSO, they decided to take their fight to the highest court in the land. They appealed both Court of Appeals decisions, resulting in two separate Supreme Court cases. GR number 232801 for the consolidation issue and GR number 234193 for the damages.
The final showdown, the Supreme Court steps in. What were the main points of contention that the justices had to grapple with?
All right, let's break it down case by case. First, GR number 232801, the consolidation drama. PCSO's main argument was, hey, if DFNNI wanted to correct the award, they should have done it in Mandaluyong, where the confirmation was already pending. Why jump to another court?
A procedural point.
Exactly. They also emphasized that consolidation isn't mandatory. It's up to the trial court's discretion. And they argued their filing in Mandaluyong wasn't actually early. They pointed to the arbitration law, Republic Act number 876, which says you can file within 1 month. Plus, they added, consolidation doesn't even make sense now because the Makati court's already issued its final decision. Case closed, they argued.
So PCSO saying too little too late for consolidation. What was DFNI's counterargument?
They basically said, look, for the Supreme Court to step in, we need to show there's been some serious harm, some injustice. And PCSO hasn't shown that. They also reiterated their point that the Mandaluyong court messed up by accepting that early filing, and they denied any forum shopping, which is basically trying to find a court that's more favorable to you.
A bit of a legal chess match. So what did the Supreme Court decide? Did they agree that the cases should have been consolidated?
They actually sided with PCSO on this one. They said, nope, the Court of Appeals got it wrong. And their reasoning was pretty straightforward. By the time the Mandaluyong court was deciding on the consolidation, the Makati case was already done and dusted. There was nothing to consolidate anymore.
Ah, moot point.
Exactly. So they reversed the consolidation order, reinstated the Mandaluyong RTC's decision denying consolidation, and confirmed the original arbitral award.
Okay, so the Supreme Court settles the procedural battle. But the big question remains, what about the money? What do they say about the $310 million versus the $27 million?
That's where GR No. 234193 comes in, the damages debate. PCSO went in guns blazing, saying the Court of Appeals totally messed up by accepting DFNNI's forum shopping argument. They also claimed the Makati RTC had basically undermined the whole legal system by issuing a conflicting decision when they knew there was a case pending in Mandaluyong. But their big argument was there was no mathematical error in the original arbitral award, no evident miscalculation.
So they're saying the arbitrator got the numbers right, the Court of Appeals should have left it alone. What did DFNNI have to say to defend their big win?
Their strategy was similar to the consolidation case. They argued PCSO hadn't shown any serious harm to justify the Supreme Court getting involved. They insisted they didn't go forum shopping, and they kept hammering on that premature filing issue in Mandaluyong. And of course, they maintained that a calculation error was clear as day.
All right, the stage is set, the arguments are made. What's the Supreme Court's verdict?
Drumroll. They sided with PCSO again. They reversed the Court of Appeals decision and brought back the original arbitral award of 27 million pesos. And they clarified a very important point, what evident miscalculation actually means.
Yeah, that phrase seems to be at the heart of this whole dispute. What does the Supreme Court say about it?
They said, look, when we talk about evident miscalculation of figures, we're talking about straight-up math errors, something you can see right there in the award document. We're not talking about disagreeing with the arbitrator's reasoning or how they interpreted the contract.
So it's not about second-guessing the arbitrator's judgment. It's about catching obvious mathematical blunders.
Precisely. And they said the Makati RTC overstepped their bounds. They shouldn't have replaced the arbitrator's decision with their own.
So after this long and winding legal road, it all comes back to that initial arbitration decision. A case that started with a contract disagreement snowballed into this huge legal battle, reaching the highest court in the land, and ultimately the Supreme Court brought it back to square one.
It's a wild ride, for sure, and it highlights some really important legal principles about how arbitration works in the Philippines and how much leeway the courts have to intervene.
Absolutely. It's like a crash course in Philippine arbitration law. And I'm sure our listeners are now legal experts after this depth dive.
Well, at least they have a better understanding of the complexities involved.
So what are the big takeaways here? What are those crucial legal doctrines that this case highlights?
Okay, let's tick them off. First up, we learned about the rationale for consolidation. Courts try to combine similar cases to avoid conflicting judgments and keep things running smoothly. But, and this is important, the cases have to be actively pending for consolidation to even be an option.
Makes sense. What else did this case teach us?
The Supreme Court really emphasized the limited reasons a court can tweak or overturn an arbitral award. They pointed to Section 25A of Republic Act No. 876 and said evident miscalculation of figures means just that, a clear mathematical error. It's not about reevaluating the arbitrator's thought process.
So courts are supposed to respect those arbitration decisions unless there's a glaring mathematical error.
Exactly. Which brings us to the next big point, the finality and binding nature of arbitral awards. The whole idea of arbitration is to resolve disputes quickly and decisively. Courts shouldn't be stepping in and rehashing the entire case.
So a nod to the efficiency of arbitration. And lastly, the Supreme Court reminded us about their own role in all this.
Right. They said their review power, especially in these ADR cases, it's discretionary. They're not obligated to take up every single case. They only step in when there's been a serious error or harm, like a lower court ignoring the rules or overstepping their authority.
So a kind of checks and balances system, the Supreme Court as the final safeguard against injustice.
That's one way to see it.
So this PCSO v. DFNN case, it's more than just a business dispute. It's a window into the world of arbitration, contract law, and the delicate balance between respecting agreements and ensuring fairness.
Agreed. And it raises some interesting questions, like how should courts approach these arbitration cases? How much scrutiny is appropriate? And what does this mean for businesses who are considering including arbitration clauses in their contracts?
Big questions with no easy answer. So To our listeners out there, what are your thoughts on this case? Did the Supreme Court get it right? Share your comments below. Hit the favorite button if you found this legal deep dive insightful. And if you want to impress your friends with legal trivia, the official citation for this case is Philippine Charity Sweepstakes Office, PCSO versus DFNN Incorporated, DFNNI, that's G.R. NOS, 232-801 and 234-193, dated June 30, 2021.
And if you're hungry for more deep dives into fascinating legal battles, the kind that keep you on the edge of your seat, hit that subscribe button. We've got a whole docket of intriguing cases waiting to be unpacked. Stay tuned, and until next time, stay curious.